want to get right to our top story, the Supreme Court decision on a major case that threatened to upend state election laws nationwide. In a 6-3 decision delivered by Chief Justice Roberts, the Supreme Court delivered a strong rejection of a fringe legal theory that had threatened to upend election laws nationwide and expand the power of state legislatures to set strict new voting rules free from state judicial oversight.
Some great news today for election laws and voting rights in this country as the Independent State Legislature theory was struck down by the Supreme Court. And for anyone who's unfamiliar with what it is, we have a little bit of an explanation here from USA Today.
In the latest round of rulings, the Supreme Court rejected what's known as the Independent State Legislature theory, which would have given state legislatures the ability to set rules for federal elections without oversight from courts. Experts worried about the implications of the case, which could have affected upcoming elections and gerrymandering and eroded trust in election systems. North Carolina Republican lawmakers asserted that the state courts were barred from overturning their congressional map by a clause in the U.S. Constitution. But the U.S. Supreme Court ruled 6-3 that courts should retain their ability to review election plans.
Now, some of you might know this case by its name. Moore v. Harper came out of North Carolina. CBS News reported that Chief Justice John Roberts authored the opinion for the 6-3 majority in the case known as Moore v. Harper, which stems from a dispute in North Carolina. The court ruled that the Supreme Court has jurisdiction to review an opinion by the North Carolina Supreme Court against state Republican officials and said the Constituents Elections Clause does not grant exclusive and independent authority in state legislators that set new rules regarding federal elections. Now, because this can be a little bit convoluted and some of the language is, it's just legalese, let's explain what the consequences would have been if the court decided the other way today. From ABC News, election and democracy experts warn the theory, if adopted in its most extreme application, could have a dramatic impact on how elections are run. State lawmakers would have near unfettered power to rewrite voting rules, potentially putting at risk mail voting, same-day voter registration, ranked choice voting systems, and other statutes for federal races. Experts previously told ABC News. They also expressed concern partisan gerrymandering would sharply increase if the theory were embraced. Now, the names of the justices who voted, in favor of this theory won't surprise you. It was Clarence Thomas, Neil Gorsuch, and Samuel Alito who joined in the dissent. Now, I'll be honest, Ben, when I really thought, and I've been paying pretty close attention to this case, I really thought that this was going to be an easy, every justice is voting the same way on this because it was such an egregious affront to democracy. And I'm someone who has no faith in the Supreme Court. And even I thought this was going to be a unanimous decision. I have zero faith. I don't even believe in this branch. And I really thought, I screamed, I scrammed when I was reading it and it said 6-3. Three justices wanted to completely destroy democracy in this country. Just like that.
I'm sorry to tell you, Ray, but you have some amount of faith left in our Supreme Court. These are the people that are caught just very recently accepting all sorts of fishing trips, people with cases before the court. If you want to buy my mom a house, sure, that's no problem. I mean, just very, very clear ethics violations, and they don't care. They don't care about anything. I mean, Clarence Thomas didn't speak in the court for 1,000 years. And then when he finally came out and spoke, he said, maybe we should undo the right to gay marriage, but not the right to interracial marriage, because that one benefits me and sweet Ginny. I mean, they are moralists, idiotic people. It's insane they're on the court. And honestly, I wish RBG had stepped down when she was alive and there could have been another Democrat on the court. That was a real mistake and an unfortunate stain or tarnish on her legacy. This couldn't be more consequential to stick around for an extra few votes. What a shame. How insane that it's not unanimous. You're 100% right. To give the state legislatures the unfettered ability to rewrite whatever election law they want within one election cycle. These legislators in the legislatures would be tearing up every single rule. They would literally be throwing it out the damn window. I mean, they would probably pass a rule instantly in Republican-led houses. Democrats don't get to vote on this one. I mean, there would be no stopping them. And this is still not even giving the federal government power. They're just saying they have to honor the state constitutions. That should be easy, but it's not. For 3 of the 9, for 1/3 of the Supreme Court of our land, they're like, whatever. I feel like elections could be a lot more loosey-goosey.
Yeah, I mean, it's ridiculous, and it doesn't give me, I mean, just having 3 of them in that category doesn't give me a lot of hope about because we got some good decisions out of the Supreme Court. This is a good decision, but it's a really bad omen of what's to come, because when we try to figure out where the Supreme Court is going to go next, we look at who's dissented in the past on these particular issues, and having 3 in that camp and a very weak John Roberts, who is very easily bullied around by the Federalist Society and what they tell him to do. And, an Amy Coney Barrett, who I wouldn't trust with anything.